and Mr.
A very good morning. I request all to be kindly seated. I would like to request Sri K.J. Lingdo, Joint Registrar, High Court of Meghalaya, and Srimati E. Shabong, Deputy Director, Meghalaya State Judicial Academy, to kindly lead the Honorable Chief Justice, Justice Sanjeev Banerjee, Justice H.S. Thank you, Shri Amit Kumar, Advocate General, and Shri S. Chakravarti, President, High Court of Meghalaya Bar Association, to the dais. May we start today's program by felicitating our honorable guests sitting on the dais. I would like to request Ms. Idahun's Aim and Ms. Bayahunlang Karmandai to please facilitate our Honorable Chief Justice, Justice Sanjeev Banerjee. I request Mrs. Alfanur Nongsiet and Ms. Dabhisha N. Thank you to kindly felicitate Sri Amit Kumar, the Advocate General, Government of Meghalaya. Ms. Nozmi Hasha and Ms. Nirasha Linkoy to please come forward and kindly felicitate Shri S. Chakravarti, President, the High Court of Meghalaya Bar Association. To commemorate the life of an important person or a loved one is to give respect by remembering and honoring his or her memory. Honorable Justice Sanjeev Banerjee, the Chief Justice of the High Court of Meghalaya, Honorable Justice W. Dingdo, Shri Amit Kumar, Advocate General, Shri S. Chakravarti, Senior Advocate, President and the High Court of Meghalaya Bar Association, Shri Vijay Hansaria, Professor David Aimley, the Registrar General, High Court of Meghalaya, the Secretary, Law Department, government officials, judicial officers, the Chief Executive Member of the Garo Hills Autonomous District Council, the Same of Khairim, respected guests, invitees, senior advocates, members of the High Court of Meghalaya Bar Association, members of the Shillong Bar Association, teachers and students of the Shillong Law College, the Department of Law, Nehu, friends, yes, family members of late N.M. Lahiri, media persons, and all of you present here today. On behalf of Honorable Justice H.S. Thank I extend a warm welcome to this N.M. Lahiri Memorial Lecture 2022. Late Narendra Mohan Lahiri dedicated his life to the development of the legal system in our state, an eminent jurist with a keen interest and understanding of our unique legal system. Justice Thank in a write-up, Building Jurisprudence, Reflections on N.M. Lahiri's Approach to Law and Life, has expressed his admiration at the passion which late N.M. Lahiri had for the 6th schedule, the tribal areas, the customary practices, and his contribution in the formulation of precedents and law in cases involving the tribal areas, and his assistance to the courts in coming to definite conclusions, which has earned him the recognition as being an authority in his subject. Mr. Lahiri's contribution to the state of Meghalaya as first Advocate General while holding his office for more than 30 years is immeasurable. The learning experience which Justice Thank had during his years as a practicing lawyer under the guidance of late N.M. Lahiri also gave room to a relationship of that of a close family member, which in his own words shaped him to where he is today. It is in gratitude and also with a sense of fulfillment which Justice Thank found it befitting to commemorate the 100th birth anniversary of late N.M. Lahiri, which also coincides with the landmark period of 50 years of Meghalaya statehood by way of a memorial lecture. The memorial lectures by Professor David Aimley, Transition in Time, an overview of the administrative structure, policy, and pattern in the hills of northeast India between 1822 to 1972, and on the 6th schedule of the Constitution, the visionary perspective of Meghalaya by Shri Vijay Hansaria will be delivered honoring the memory and contribution of an eminent jurist, late N.M. Lahiri. Honorable judges, respected speakers, guests, invitees, and all of you present here today, on behalf of Honorable Mr. Justice H.S. Thank I welcome you to the N.M. Lahiri Memorial Lecture 2022. I would now like to request the Honorable Justice H.S. Thank to kindly give the opening address.
Thank you. The Honorable Chief Justice, my brother colleague, Justice Dingdo, the Advocate General, President of the High Court Bar Association, the esteemed speakers for today's lecture, Professor David Aimley and Mr. Vijay Hansaria, Senior Advocate, the Law Secretary, respected Same of Khairim, Senior Advocates, judicial officers of the district judiciary and district council courts, the advocates of the High Court District Bar Association, my dear students and their respective faculty members, distinguished guests, ladies and gentlemen. Actually, I don't know where to start from in giving this opening address. And I was just, in my mind, I was trying to craft some kind of a very a speech that's befitting. But anyway, firstly, I'm indeed very happy and overjoyed to see and the response that we have got from the students, young lawyers, and from the section of society across the board with regard to attending this lecture, which is incidentally being also live streamed on YouTube. And I am sure that many of the people who had given me the responses have joined us through the virtual mode. So I welcome all of them also today. I may say that this lecture today, it's more for the young minds, such as the young lawyers and the students, because as Mr. Lahiri was very, very passionate about, building up the capacity of, local lawyers and tribal lawyers. He used to say, but he used to say there are no tribal, non-tribal lawyers. All lawyers are lawyers. And also the students that, he held very dear. And when I joined his chamber in the year 1991, in fact, he had taken me down there. So he said that you have to understand, the ethos of your own region and land. And so, on this commemoration of his 100th birth anniversary, I felt that, maybe it's a little something I can do, that to remember him. He was a legal giant of his time. And a happy coincidence is that it has coincided with the 50th year of statehood of our state. And incidentally, he had served as Advocate General for over 31 years, which undoubtedly, I think, he was the longest serving Advocate General anywhere in India since post-independence. So, and the service he rendered, it was not only limited to the office of Advocate General, but much before the Association District Councils. If you go through all the rulings or citations, the journals, you'll see from the inception of District Councils, where he was a legal advisor, till the coming into force, of the state, he was, a very, very important feature of, their deliberations in the court, and how, like in that article I'd written in the journal, how he shaped jurisprudence, the shaping of law with regard to these areas, especially on interpretation of 6th schedule. Just a little background about him is that he incidentally never wanted to be a lawyer when he was young, and he was involved in politics, and in fact was a member of the Revolutionary Communist Party of India. And he was jailed also in Jorhat under the Detention Act, and was interned in Shillong later on, though he has a house in Shillong. So in 1949, he joined the profession and was in the profession till his death in 2006. But you can imagine at that time, 1949 was post-independence, pre-constitution. So everything was a very, very fluid state with where was our country going, and what was in store, especially in the legal landscape, with the coming of the constitution, then with the coming of the 6th schedule. So these things were very, very, tumultuous times, you can say. And he navigated all these from the time he joined his profession. So I would say he was fortunate because he was born those times. So by the time we entered the profession, a lot of things had already crystallized. So in those years, he came out as an expert, and he was known as a resident expert, on the 6th schedule. Now, on the other part of his life, he is not only, I will not dwell on the rulings or the citations or the other cases we had dealt on. Of course, the important cases which I'm sure the other speakers might speak on. So he loved these hills. He loved these valleys, and he was totally in sync. In body and soul, he was never like a visitor. So he's taken me on many trips. Light Loam, for instance, was unknown. That time was late 80s or early 90s. Nobody knew about Light Loam. We used to go there. We had to walk for a fair bit. And, and the other places which he has taken, and his intimate knowledge of these hills, so that also gave him a sense of a deep belonging. And so he was, like I said, very passionate about the development of law. And so he's in his conversations with me, he used to say that I want to bring up, there's so much talent. And you can never say that tribals of this area are more, behind anybody, he said. He said that is something which is unreal. So anyway, and he loved plants. He maintained a beautiful garden, and he took care of his guardian in such a manner, and all the other things. So he was in fact a complete person in many ways, and in his honor, I am happy to say also, I see some of my past colleagues also, like Mr. Saiwala there, then I see Babita Sharma here, then Mr. Banlum Lang, who's come all the way from Bombay to be here today. So we are all part of the same family at a point of time. So with these few words, thank you very much, and I hope especially the young minds here get some valuable takeaways from the lecture that will follow. Thank you. Mithela, Jai Hind.
Thank you, sir, for your opening address, and thank you for giving us a glimpse of the life and work of late N.M. Lahiri with a personal touch. We are happy to have the President of the High Court Bar Association, Sri S. Chakrabarti, here with us. I would request you, sir, to kindly come here and give your speech.
Your Lordship, Honorable the Chief Justice, Your Lordships, Honorable Justice, thank you, and Honorable Justice Dingdo, the Advocate General, all the dignitaries whom I see here today, leading citizens of this city, my colleagues in the bar, students, and all of you present here. A very good morning to everyone. Indeed, I deem it to be a great privilege and an honor to be able to stand here this morning to pay my homage on behalf of myself and on behalf of the legal fraternity of the state to one of the towering giants of all times of the bar from these parts of the country. We were indeed so very fortunate to have had occasions to interact with Sri N.M. Lahiri when he was still active in the bar, to have been able to follow him in course of his professional discourses and professional services, and also, to a certain extent, to have known him as a person. Undoubtedly, he has left an imprint, a marked imprint on the minds and hearts, and also on the professional techniques of many a lawyer of the northeastern parts of the country, and also probably of other parts of the country. He hailed from one of the leading families of settlers in Guwahati who were in the legal profession for decades, and the family has produced many dignitaries. I remember at least his father, who himself was a leading lawyer of Guwahati, and one of the most remarkable Chief Justices of the olden days, His Lordship Kiranmoy Lahiri. When we had joined the bar, those days they were legends of the profession. I personally, I have had occasions to interact with him and also to have participated in legal proceedings. One of the cases which I remember here in Shillong was the case of the different clans, 3 different clans, which had filed a petition, a writ petition, for taking back the areas which had been handed over on 99 years lease, which is known as the Kharkongor clan case normally. And I was so very fortunate. I was representing the central government in that case, and I was so very fortunate to have participated in that proceedings and to have learned so much indeed about the history of this city from the submissions of Sri N.M. Lahiri. There have been other so many instances also, so many landmark cases. Indeed, I don't think it's necessary to, come up with a list of all that now. But in this 100th year of his birth, that we have gathered here today to pay our homages to him, to remember him, this itself goes a long way to show how much, imprint he has had on the minds of the people with whom he interacted and how much he has left behind for us to imbibe and to follow. I don't want to talk much, but just 1 or 2 more words. I also take this opportunity to congratulate His Lordship Justice, thank you, for taking the initiatives and so successfully organizing this meet here this morning. It's indeed a very befitting tribute by a junior of the chambers of Sri N.M. Lahiri. I see the family members here, and I cannot but recall that the whole family of Sri Lahiri had left indelible marks in their respective areas. And in this regard, his wife, Mrs. Anjali Lahiri, I have to mention, in particular because she had been one of the leading lights of the Bengali literary scenario in these parts of the country. So I congratulate once again, Justice, thank you, and all others who have been involved in organizing this function with him. And I thank them from the core of my heart for having given me this opportunity to stand here and address this august gathering. Thank you very much. Jai Hind.
Thank you, sir, for sharing with us your experiences and for sharing with us the contributions of late N.M. Lahiri. From the Office of the Advocate General, Government of Meghalaya, we have with us Sri Amit Kumar, Senior Advocate and Advocate General. Sir, I would request you to kindly come forward and share a few words with us.
Honorable Chief Justice Sri Sanjeev Banerjee, Honorable Mr. Justice H.S. Thank you, Honorable Mr. Justice W. Dingdo, Sri S. Chakravarti, Senior Advocate, President of High Court Bar Association, Mr. Vijay Hansaria, Senior Advocate, Dr. David R. Simley, former Chairman UPSC, Cyril Dingdo, Secretary Law, Department of Government of Meghalaya, Registrar General of the High Court, learned members of Judicial Services of the State of Meghalaya, law officers of Central Government and State Government, my esteemed colleagues and members of the August gathering. It is indeed a great honor and privilege for me to say a few words about Sri N.N. Lahiri, who served the State of Meghalaya as an Advocate General from 1972 till 2003 for a period of 30 years. I am also extremely grateful to Justice H.S. Thank you for organizing the present lecture in memory of his Guru, Sri N.M. Lahiri, giving us opportunity to pay our humble tribute to a great legend. I did not have privilege of knowing Sri N.M. Lahiri personally, but the image which I have constructed of Sri Lahiri is based on reading of his arguments in number of cases. The image of Sri Lahiri was not only of legal luminary, but was of a person who was committed to protect the identity and culture and legal rights of people of Meghalaya. I am informed that Sri N.M. Lahiri was instrumental in drafting number of legislations, not only for the State of Meghalaya and also for District Council. Thus, I would not hesitate in saying that he is B.R. Ambedkar of the State of Meghalaya. I was also truly impressed to see the collection of books on diverse subjects in the Chamber of Advocate General, which is situated in the Secretariat building. I inquired from my colleagues from the Law Department as to who has collected these diverse books, and I was told that the entire collection is of Sri N.N. Lahiri. It shows how much effort Mr. Lahiri has put in not only going through those books, but absorbing them and using his knowledge for the benefit of people of the state. There are a number of judgments which show the reflection of argument of Sri Lahiri, but having regard to paucity of time, I will refer two landmark judgments in which Mr. Lahiri's contribution is greatly reflected. The very place where I am standing today is also because of acceptance of argument of Sri Lahiri by the full bench of Guwahati High Court in the case of Nongkhao clan versus Union of India, which Mr. Chakravarti has just now referred. Mr. Lahiri's argument in that judgment is worth reading, and I would urge all law students to read that judgment, how painstakingly Mr. Lahiri has traced the history of British Crown in this part, nature and recital of lease documents, whether they were determinable or in perpetuity. Based on submission of Mr. Lahiri, Honorable High Court held that lease deed of land which was executed by Nongkhao clan with British government on which Governor's House, Secretariat building, and if I am not wrong, the present High Court are standing, are perpetual in nature. If Mr. Lahiri would have lost the case, we would not be having this place where we are standing today. So his contribution in making the institutions of the State of Meghalaya is comparable to none. The state has immensely benefited from his legal acumen. Mr. Lahiri played a pivotal role in shaping the laws on 6th schedule. As Justice Thank You has said, that it was on cusp of pre-constitution and post-constitution, and his contribution in shaping the laws of sixth schedule are worth remembering. And I really thank you once again for organizing this lecture in his memory. One judgment which is there, Miss Sitman Saiwan, in that judgment of 1968, the contours of legislative power of the district council under paragraph 3.1 was settled. By holding that paragraph 3.1 of sixth schedule, district council has no competence to legislate on the transfer of land, and the district council had no plenary power of legislation. The judgment remains a landmark ruling in the matter concerning the extent and scope of power of legislation conferred on district council. In my view, the invaluable contribution of Mr. Lahiri in the form of detailed and meticulous research provided much needed guidance in navigating the tricky route of balancing customary law and statutory law. While I was researching on the writings of Mr. Lahiri, I came across one article authored by Sri Lahiri, and the title of the article is A Brief Account of Administration of Law and Justice in the Tribal Areas of erstwhile Assam at the commencement of the Constitution, and thereafter with a special reference to the Meghalaya. In the said article, Mr. Lahiri, in concluding paragraph, has discussed the culture, ethos, and the issues which are troubling the state of Meghalaya. And I would quote his paragraph to pay my tribute and to highlight his contribution to the state of Meghalaya. I quote, "It is no doubt desirable that judiciary should be separated from the executive as has been ordained by the Constitution in Article 50. The High Court also in this regard is constantly observing that it is high time that judiciary and executive are separated in this area, and many attempts by the Honorable Chief Justice and the authorities of the state government to find out ways and means for this separation have also been made. However, in view of the historical background and unique system of administration of law and justice in these areas, it became difficult to translate it into reality. There is no denial of the fact that there is a dearth of competent persons interested in serving as judicial officers in this region to hold the reins of judiciary. It would not be practicable to man the post with people from outside those areas. That apart, persons appointed from outside these areas without any knowledge of language and ethos of the people will find it difficult not only to adapt to the environment but also to administer justice." So these lines truly reflect the ethos of Justice Lahiri, which was also highlighted by Justice Thanku in his introductory speech, that he believed that the people of this part has to be nurtured, has to be brought about the various dimensions of law, and that is how he helped the state for 30 years. I would say that the paragraph would show his deep understanding of culture, legal system, customary practices of Meghalaya, and above all, people of Meghalaya. That is why for more than 30 years, government after government depended on him on legal advice. With these few words, I conclude my tribute to Sri N.M. Lahiri. Thank you very much. Jai Hind.
Thank you, sir, for giving us a picture of the tenure of late N.M. Lahiri, the first Advocate General of the state. Mr. Lahiri's contribution is appreciated and has left an indelible mark in the legal system of our state. The Honorable Minister of Law, Government of Meghalaya, Sri James P.K. Sangma, is unable to be present with us today. However, the Honorable Minister has expressed his appreciation and gratitude to the Honorable Justice H.S. Thanku for organizing this memorial lecture to commemorate the 100th birth anniversary of late N.M. Lahiri, the first person to adorn the constitutional office of Advocate General. The message of the Honorable Minister reads, I wish to extend my sincere gratitude to Honorable Mr. Justice Thank You for organizing a memorial lecture to commemorate the 100th birth anniversary of late Shri N.M. Lahiri, the first person to adorn the constitutional office of Advocate General of Meghalaya, and to graciously carry out his responsibilities of the post for more than 30 long years since the inception of the state till 2003. The occasion has also incidentally coincides with 50 years of statehood for the state of Meghalaya. I extend my best wishes and gratitude to the organizers for remembering a legal luminary, eminent jurist, lawyer, author, and socialist in the best possible manner by spreading legal awareness of laws relating to the state of Meghalaya through this lecture. I am sure that the lecture will benefit the present and future generations in understanding the legal framework concerning the state of Meghalaya. The support of the Honorable Chief Justice, Justice Sanjeev Banerjee, without a doubt is an enabling factor for Justice Thank You to proceed with the preparation of this memorial lecture. It is an honor to have His Lordship grace this occasion with his presence and also by delivering a speech to this gathering. I now request His Lordship to kindly address this gathering.
My dear colleagues from the bench and the bar, venerable speakers, respected dignitaries, distinguished guests, judicial officers, students, ladies and gentlemen, physically in attendance and with us on the virtual mode. Good morning. We are here to hear our two main speakers and not me. But I want to dwell on two aspects. The first is the relationship between a junior and a senior that was so remarkable and which I think is being lost in present times. The practice of deviling, getting into tutelage under a senior, following the coattails of the senior, as it was known, and bringing up the rear of his gown. That was how juniors in the profession entered the profession and learned their ropes. There is a gestation gap which is necessary in this, what used to be a noble profession. You cannot come in, be enrolled yesterday and expect to start arguing today or even eking out a livelihood. There is some time that is needed for you to learn the tricks of the trade, so to say, in the most dignified sense. And there is a huge gap between the theory that may be taught in law colleges and the practice in the courtrooms. Unfortunately, we have more than 2,000 law colleges at the present, with only a few of them imparting the kind of education that is necessary. We are rolling out lawyers by the hundreds every year who are eager to earn but impatient to wait. And oftentimes we see clashes in courtrooms now that we had never imagined could happen. The relationship between a senior and a junior was one of a family. Indeed, coming from a legal family, I am relieved today that my son and daughter have not taken to law. The charm that was there is no longer there, and I only hope that this is a passing phase and the nobility in the profession will be revived. Standing here, I pay homage to Mr. N.M. Lahiri. I had no occasion to meet him, but from all accounts, he was a giant. The very fact that he continued in office for 31 years through several governments would be a testimony to his status and stature. The other aspect that I want to dwell on is the good fortune that I have had in coming to this neck of the woods, getting to know Meghalaya, enjoying the bounties of nature and its wonderful people. It's been a privilege, and my message to all of you in Meghalaya is keep your identity, hold on to the traditional practices, but to the extent such traditional practices are in keeping with the constitutional ethos. There is an attempt at the moment of homogenization in the name of unification. We must guard against homogenization. There is so much wealth in the diversity that we must respect and live up to our individual traditions and practices. Unification and homogenization are not the same thing, and that is what we must guard against. I'm grateful to Justice Thank You for giving me the opportunity, and I wait as keenly as the rest of you to hear our respected speakers. Thank you. Jai Hind.
Thank you, sir, for your insightful and delightful speech. It is a pleasure to know that our Honorable Chief Minister, Shri Conrad K. Sangma, has shared with us a message to mark his support and appreciation to Justice Thank You for organizing this program. Let us now watch and listen to the message of the Honorable Chief Minister.
My warm greetings to Mr. Justice Sanjeev Banerjee, Honorable the Chief Justice of the High Court of Meghalaya, Mr. Justice H.S. Thank You, and Mr. Justice W. Diengdo, the Honorable Judges of High Court of Meghalaya, Shri Amit Kumar, the Advocate General of Meghalaya, Shri Vijay Hansaria, Senior Advocate, Dr. David R. Siemle, the former Chairman of the UPSC, and members of the August gathering. I take this occasion to express my heartfelt gratitude to Honorable Mr. Justice Thank You for providing me the opportunity to express gratitude to late Shri N.M. Lahiri, the first Advocate General of the state, who held the constitutional office for more than 30 years. that is from 1972 till 2003. Late Shri N.M. Lahiri was a key legal advisor from 1969 when autonomous statehood was obtained. The state of Meghalaya is blessed from the day of its inception when late Shri N.M. Lahiri graciously accepted the duties of the office of the Advocate General of the state, which had just been born, and to guide the state from its nascent stage for a period of more than 30 years. Late Shri N.M. Lahiri rendered yeoman services to the people of Meghalaya. His 100th birth anniversary, coinciding with 50 years of statehood of Meghalaya, is an apt time to remind ourselves of the contribution of late Shri N.M. Lahiri in building the state and also drawing inspiration from the same. His continuous service to the state as Advocate General for more than 30 years is testimony of his legal acumen, standing, ability, and contribution to the state in particular and public in general. This becomes significant also in the light of the fact that despite change in the government from time to time during the period he adorned the office of Advocate General, all successive governments continued to repose faith in him and his abilities. It is not a small achievement when we are living in the world preferring frequent changes. Being an eminent jurist himself, his chamber produced a number of eminent jurists, renowned advocates, judges including Honorable Mr. Justice A.K. Goswami, the current Chief Justice of Chhattisgarh High Court, late Mr. Nishitendu Chaudhary, Judge, Guwahati High Court, and Honorable Mr. Justice Thank You, who went on to contribute to the society and serve humanity in different ways. The challenge to advise the state government of Meghalaya in 1972 was immense because of the uniqueness of constitutional status of the state, which is governed by the 6th schedule to the constitution as a mini constitution in itself, which required a person who not only understands the nuances of law but also the practical aspects of life of the people of Meghalaya. Late Mr. Lahiri successfully handled the responsibility throughout his tenure. I was not fortunate enough to have had an interaction with him personally, but day in and day out, I have been working with the legal institutions created by late Shri N.M. Lahiri, and he has left behind an indelible imprint. I wish all the success to the organizers of the memorial lecture and hope that fruitful discussions which will take place will certainly inspire all of us. Thank you. God bless.
A special gesture of gratitude will be extended to the Honorable Chief Minister, Shri Conrad K. Sangma, and to the Honorable Minister of Law, Shri James P.K. Sangma, for their support and their messages. We have now come to the end of this inaugural session. I would request Shri K.J. Lingdo and Srimati E. Shabong to please escort the dignitaries from the dais to their seats to join the other guests. In today's memorial lecture, we are happy to have with us two speakers, Professor David Aimley and Sri Vijay Hansaria. The first lecture, Transition in Time, an overview of the administrative structure, policy, and pattern in the hills of northeast India between 1822 to 1972, will be delivered by Professor David Aimley. We're happy to have here with us Dr. Aimley, who is an academician, a historian, an author who has written and edited many books and articles. Professor Aimley has held numerous positions in the Northeastern Hill University and was also the former Vice-Chancellor of the Rajiv Gandhi University in Arunachal Pradesh and also the former Chairperson of the Union Public Service Commission. I would like to request Professor Aimley to please come forward and deliver your lecture. So as a token of appreciation, we would like to felicitate you.
Honorable Justice Sanjeev Banerjee, Chief Justice, High Court of Meghalaya, Honorable Justice H.S. Thankyu, Judge, High Court of Meghalaya, Honorable Justice W. Dingdo, Judge, High Court of Meghalaya, dignitaries, students, friends, advocates, thank you very much, Justice, thank you for inviting me to deliver this lecture. In my retirement, I'm doing more than I had ever done before, particularly in this virtual age. But as an old teacher, I love to come back to a classroom scenario, and that's what I will be doing today. Kindly bear with me, because I'm not too good with my computer and I don't have a laptop as others would have to assist them. And I make my presentation reading out for clarity and to keep time. When asked to give a lecture today, I decided to go back to my old texts, because what I found was that students of law, perhaps very cursory, go back to the past. And we need to go back to the past to understand the present. And therefore, I'm making a presentation today on transition in time, an overview of the administrative structure, policy and pattern in the hills of Northeast India, 1822-1972. Early under British rule, the hill areas of the Northeast, which over centuries had developed their own respective forms of administering themselves, were given distinct administrative mechanisms within the non-regulation system. Operated first among the tribes of Chotanagpur, the pattern was applied to the Garos soon after a section of their hills were brought under British administration. Regulation 10 of 1822 suspended the operation of the existing rules and regulations for the administration of civil and criminal justice. What I find very interesting in these old laws that were applied as early as 1822 was that the poor Garos didn't understand anything of that law. And therefore it was imposed on them. And through British rule, there are so many numerous instances where rules and regulations are applied, but the poor innocent people are not aware of what guides them in the new form of administration. The powers of the district magistrate and judge were combined in the same person, subject to the control of the Governor General. There was no collection of taxes other than a house tax. The administration was simple, allowing the local chiefs to continue the management of their people in what was called indirect administration, which the British were subsequently to apply to Malaya and Nigeria. The company acquired other hill territories in the region. As the company acquired other hill territories in the region, they were brought under this pattern of administration. Many years later, subsequently, Act 22 of 1869 repealed the Regulation 10. The pattern of administration included, among other features, exemption from the jurisdiction of the regular civil and criminal courts. A number of regulations and enactments were subsequently put in place, which included the Inner Line Regulation 1884 to give the tribes the distinct administration, many features of which continue till today. Though it came late, administrative devolution with increased number of Indians in the legislature and the administration was put in place. The process began with the Indian Councils Act 1892. Representation was provided by the Act of 1909, and Dayaki was introduced by the Act of 1919. Put into operation in 1922, it continued to function as an administrative arrangement till 1937. The Government of India Act 1935 then gave new nomenclature, terming these areas earlier called backward tracts. Here's again another application of a term which is very unkind, terming these areas backward tracts to either excluded areas or partially excluded areas. The excluded areas were under the executive control of the Assam governor. The partially excluded areas were under the control of the governor and subject to ministerial administration. But the governor had an overriding power when it came to exercising his discretion. No act in the Assam or Indian legislatures could apply to these two hill divisions unless the governor, in his discretion, so directed. He was empowered to make regulations for the hill districts which had the force of law. The administration of these hills was a special responsibility. With no representation in the assembly other than the partially excluded areas which sent one legislator each, political activity above their village and local levels could hardly have existed. Political consciousness in the hill districts, however, can be seen early in the establishment of the Jaintia Darbar in 1900, the beginning of the Naga political activity with the establishment of the Naga Club 1918, and the hectic political maneuverings of the Khasi National Darbar set up in 1923, and the Federation of Khasi States formed in 1934. The pace of political activity would increase shortly before August 1947 and after. Within the commissionership province were the 25 Khasi states. The Khasi states were normally under the administration of their chiefs, Aims, Lingdos, Sirdars, and Wahardadars in Darbar, with only a supervising attention from the Deputy Commissioner of the Khasi and Jaintia Hills district, who functioned as their political officer. Along the watershed between Burma and further north in the hills reaching the eastern Himalayas lived Naga tribes, Meris, Monpas, and a kaleidoscope of other kindred people who were, as the term went, unadministered. Here again, another term which is very unkind. They administered themselves, right? They have their own forms of administration, which should be appreciated. Their hills were only occasionally visited by the British in punitive expeditions and survey operations. The Naga tribal area and the Tirap frontier tract were technically and for practical purposes outside British India. There was a statutory boundary between these two frontier tracts and the adjoining districts of the province. While this boundary had been defined, by an oversight, no similar notification was issued for the northern boundary of the Assam province, and it was thus assumed that the whole territory up to the Indo-Tibetan frontier was de jure an extended excluded area and so theoretically formed part of the province. However, this interpretation was contrary to the administrative position, because while the Government of India treated the areas as tribal and unadministered, treaties in 1862 and 1874 with the tribes of these hills refers to them as foreign, and a distinction made between the boundary of British India and these hills of the eastern Himalayas. Administrative officers stationed in Tezpur, Balipara and Sadia were responsible for keeping a close watch on the hill tribes of this frontier and the management of Posa. Posa was a type of tribute which the hill chiefs got from the administration in the plains. Administrative reorganization. From 1862 to 1874, the Assam Commissionership was administered under the Governor and the Lieutenant Governor of Bengal. In 1871, the Secretary of State for India gave his assent to the proposal that Assam and certain eastern districts of Bengal should be constituted into a Chief Commissionership to be placed directly under the Governor General. On 7th February 1874, 5 districts of the Brahmaputra Valley, the Naga, the Garo, Khasi, Jaintia Hills, and Golpara became part of the Chief Commissionership of Assam. Sylhet was tagged on to the new arrangement in September that year. Almost immediately on assuming office, Colonel R.H. Keating was called upon to select the headquarters of the new administration. The choice was between Guwahati and Shillong, only recently made the headquarters of the Khasi and Jaintia Hill district. Keating opted for Shillong not only for climatic considerations, but because accommodation was easily available in the hill station. The place was capable of indefinite expansion, and the cost of building material was cheaper in the hills. No doubt Guwahati was closer to 8 districts, while Shillong was closer to Cachar and Sylhet. Moreover, there was a political advantage having Shillong as a base, as it was approachable from 2 directions. On 24th May 1874, Lord Northbrook approved the selection of Shillong as the headquarters of the Chief Commissionership. Before the next round of adjusting administrative boundaries, suggestions were placed at different stages that Chittagong Division, Dakar and Mymensingh districts and the Lushai Hills, present-day Mizoram, be transferred to the Assam administration. Bengal was partitioned in October 1905. The new province of Eastern Bengal and Assam provided the Lieutenant Governor's province with a separate civil service, gave benefits to tea, oil, and the coal industries, and provided an outlet to the sea at Chittagong. We will not discuss the anti-partition agitation and the Swadeshi movements and the fallout these had on the partition of Bengal. We may, however, note that this was the first real concern the administration of the new province had in dealing with an agitation the likes of which had not been witnessed earlier. When the partition of Bengal was annulled in 1911, largely due to agitation against it, Assam reverted to a Chief Commissioner's province, with Shillong again becoming its capital. In real terms, the capital hardly had shifted to Dhaka. In fact, much of the office continued to remain in Shillong. War, councils, politics, and independence. Assam supported Britain in the Great War of 1914-1918. The province pledged the war cause with donations and sent out numerous combatants and several hundreds as labor corps. From the Assam administration, 174 officers were placed in military duty. In the aftermath of the war, though, there arose discontent with the rise of essential commodities and general increase in the cost of living, with post-war inflation. Discontent gave way as elsewhere in India to Assam's participation in the national movement in large numbers and across communities. The administration was faced with tackling the national movement, commencing with the Rowlatt Satyagraha, the Khilafat agitation, the non-cooperation and civil disobedience movements, and the very active participation in the Quit India movement. The Second World War exhibited the Indian people generally had no support for the war. Japan's participation brought the theatre of the war to the eastern frontier of British India. Burma was overtaken in 1942. The Japanese advance was stopped along Manipur, the Lushai Hills, and the Naga Hills. The war strained the Assam's administration for men and financial resources, even while the national movement was at a low ebb during these years. Inasmuch as the war showed tribal support for British administration, it also threw up the dilemma for the administration of large-scale support for Subhash Chandra Bose's call to enter India through the northeast with the slogan, "Chalo Delhi." Electoral politics and the formation of government added a new dimension to governance in British India. Hitherto, the Indian civil service officers, the steel frame as it was called, of the British Raj, and the subordinate services including the judiciary, police, revenue, and so on, were directed by the colonial policy of keeping the peace and collection of revenue to meet expenditure. There was little infrastructure development. No large-scale plan were mooted for agriculture and industry, other than the development of tea, oil, and railway, which had colonial interests. The plight of the immigrant and indentured tea garden laborers was hardly a concern for the administration, other than some rules for their care. Natural calamities such as flood and earthquakes were of concern for the administration, for these had frequent and was devastating, as was the great earthquake of 12th June 1897. At this stage, I must go back to that earthquake because an English gentleman passed away there and a road was named after him. His monument was on that road, but far from this place, and the monument is no more. And I would request the state government to at least do something to revive the memory of that police officer who died, and the memory in keeping the monument that was raised for him. The Lushai Hill administration was particularly engaged in supporting the population at the time of the famine, which occurred twice in our period of study. On the other hand, during British rule, Assam, as other provinces in India, experienced slow but careful building up of institutions of governance. The legislature for legislation and policy making, the judiciary, the executive, law enforcing agencies, revenue collection, education, healthcare, and so on. It was to be on these structures that the Indian state would work on to set up more elaborate administrative machinery. Hitherto, the administration had been colonial, to say the least. Electoral politics brought people's representation who took up issues very different to the administrator. Assam's representatives in the councils, Muhammad Saidullah and Gopinath Bordoloi, to name but two, were concerned that Assam, despite being a much less developed province, was not receiving financial support it ought to have got, for Assam was made to pay for the administration of the deficit backward tracts and the Assam Rifles. In 1928, Kanaklal Barwa told the Simon Commission that the province of Assam should be geographically compact and therefore the hill areas intervening between the Assam Valley and the Surma Valley should remain in the province. He meant that the Khasi and the Jayanti Hills, the Garo Hills and the Mikir Hills should not be taken away from Assam, while the Lushai Hills, the Naga Hills and a part of the North Kachar Hills should be excluded from Assam. Saidullah held the same view, and the powerful Indian Tea Association in Assam was of the same opinion. Two British administrators, John Hutton, Deputy Commissioner Naga Hills, and N.E. Pari, Deputy Commissioner Lushai Hills, were for separation for hill areas from any general administrative scheme and the device for Assam. This would later be discussed in high circles as the Crown Colony Protectorate Plan for the hill areas of Northeast India. It was also brought to the notice of the Simon Commission in 1928 that Assam did not have a high court or a university of its own. Institutions of higher education were few and communication in the province was the poorest in the country. Much of the tax on tea was remitted in London and Calcutta, and it did not contribute to the coffers of Assam. Bodoloi later pleaded in the Constituent Assembly for special treatment for Assam in the background of post-war and post-partition burdens. He was joined by Omyo Kumar Das and J.J.M. Nichols Roy that Assam was facing chronic financial difficulties. Post-1947 concerns. And I ask a few questions, and I would request those who are interested in history and scholars to try and answer them, because I've done my bit and I'm posing these questions today. Was there discernible change in the administrative policies and programs after independence? Did independence usher in dramatic change in the attitude of the administrator? Was there perceptible change among the administrators from serving under colonial rule to serving in free India? Did they realize the new role entrusted to them in nation building? These are questions that may be asked. It would be of interest to know the views and opinions of those who have left behind their memoirs and records before they fade away from memory or are lost. To be sure, not all the British administrators left their Indian service, though many could not see themselves working under an Indian administration. This transition period has not been studied in detail, and I would urge scholars to look at this transition because there's so much to understand of that past. Of immediate concern for the Assam administration was the problems arising out of the new boundary with East Pakistan, the dislocation of communication and supplies, the movement of peoples across the boundary into India and their settlement. The Assam administration had also to put in place the setting up of autonomous district councils for the Garo, Khasi, Jayanti, Karbi, North Kachar, and the then Lushai Hills. Post-partition administration adjusted to the challenges of making democracy work with elections. Growing demand for administrative units, hill area administration, including the setting up of the Indian Frontier and Administrative Service for NIFA, and the first three of the 5-year plans. During these early years after independence, there was a steady integration of communities into the sense of being part of the Indian nation. The hill people could have lived peaceably in Assam, but for the attitude of some Assamese legislators. Hardly had the British left when Assam's representatives in the Constituent Assembly advanced assimilationist views. We want to assimilate the tribal people, a member of the Constituent Assembly from Assam said. We were never given that opportunity so far. The tribals did not want to be assimilated in this manner. It would not be long before the cordial relations between the Assamese and the hill people would end. By then, negotiations had gone far ahead with the Nagas for the incorporation of the hills into the Indian Union. When these failed, military pressure was applied on the Nagas, which, if it did not solve the problem, actually worsened the situation. For the Nagas, a sense of dismay and alienation set in, which sadly remains till date. Hardly had the situation erupted, the administration was forced with another outbreak by a section of the Mizos who rose in arms over the mishandling of the relief during the Maltwam, eventually becoming a very serious struggle of the MNF against the Indian state. Here too, military and punitive action and the regrouping of villages was the policy of the government, which, like the Naga situation, resulted in a very long, drawn struggle for the MNF. The whole story of these agitations have not been brought to the front. And again, another round of study could be done to get these full stories out. If these two local situations could be handled in ways thought fitting by the administration, India got a jolt from the Chinese intrusion in 1962. This intrusion prompted a change in policy and direction for the entire region. Post-1962 witnessed the increasing military presence in the region. The center gave attention to the region as never before, with increased outlay of funds for infrastructure development, improved communication of roads, railways and airfields and more. The administration of NIFA, so complacent before this jolt, got a boost. One of the achievements of post-independence India was the abandonment of the policy of isolation of the tribes. In this, Assam moved forward more inclusive administration, but not sufficiently, and it affected the unity of Assam. In the fitness of things, the state of Nagaland was formally inaugurated on 1st December 1962 as the 16th state of the Indian Union. Through the 1950s and into the 1960s, the hill people demanded separation from Assam. What really set their movement towards breakaway from Assam was the decision of the Assam legislature to make Assamese the official language of the state, in a state which perhaps had the largest number of languages and dialects spoken in any Indian state. The Hill State movement, which has gone down in history as largely non-violent, took advantage of this enforcement of language to press their demands. Eventually was brought in the autonomous state of Meghalaya in 1969 with full statehood 2 years later. It was some time, though, before Meghalaya would have its own High Court, Public Service Commission and Governor. The Northeastern Areas Reorganization Act 1971, enacted by Parliament on 30th December 1971, provided in its comprehensive legislation for the establishment of the states of Manipur and Tripura and the formation of the state of Meghalaya and of the Union territories of Mizoram and Arunachal Pradesh. The reorganization took effect in the early part of 1972. And I'm coming towards my conclusion. Home is where the heart is. The people of this region have an especial attachment to their land. Shown from their land, they almost cease to be who they are. On the other hand, there are those unfortunate persons who have had no home and want one. It triggers migration. The Northeast has received migrants over centuries who have made these beautiful hills and green valleys their home. Of concern, however, is that migration into the region in more recent times has disturbed the demographic composition of the region. And I'm at my last paragraph. While politically and culturally the people of the two hills were within the Indian ethos, those of the hills were given this identity following their incorporation into the colonial state and political control by the British. Administrative arrangements following the extension of British imperialism and the political and change of governance after 1947 provided an Indian dimension in the lives of the people of the region as a whole. In the 75 years following independence and integration of these areas into the Indian state, significant cultural, linguistic, indeed an emotional connection with the people of the region with the Indian state is evident, the integrative principle of which has not been fully appreciated and studied. Kublai.
Thank you, Professor Simle, for an insightful and informative lecture, which I believe all of us here have gained much. The research work involved is evident in the details of your lecture. Thank you, sir. We wish you well as you continue to teach and reach out. Now we look forward to the second session, the sixth schedule of the Constitution, the Visionary Perspective of Meghalaya, with Sri Vijay Hansaria. Sri Vijay Hansaria is a senior advocate in the Supreme Court of India. He is the son of late Justice B.L. Hansaria, who after completing his master's in economics from the London School of Economics, joined the law profession. Sri Hansaria has revised Justice Hansaria's book on writ jurisdiction, which has been received well by many readers. He has also edited a working manual on the juvenile justice system in India. It is a pleasure to have you here with us, sir. I would request you to kindly come here to the dais.
Namaskar. Honorable Justice Sanjeev Banerjee, Chief Justice, High Court of Meghalaya. Honorable Justice, thank you. Judge, Meghalaya High Court. Honorable Justice Dingdo, Judge, Meghalaya High Court. Professor David C.M. Lee, academician, historian, former chairman of Union Public Service Commission. Mr. Amit Kumar, Advocate General of Meghalaya, the Law Secretary, State of Meghalaya, Registrar General, High Court of Meghalaya, Mr. Subhasis Chakravarti, President, Meghalaya High Court Bar Association, judicial officers of the State of Meghalaya, family members of Mr. Lahiri, my colleagues in the bar, officers of the state government, faculty members and law students who are good in numbers here, members of the media, print and electronic, ladies and gentlemen who are present here, and also those who are on live telecast. I'm really privileged and honored that I've been here, I've been called to come here to deliver first N.M. Lahiri Memorial Lecture along with Professor Shamli to commemorate 100th birthday of Sri Lahiri and 50th year of the statehood of Meghalaya. Lahiri was the first Advocate General of the state of Meghalaya, as all the speakers have said. And it is a history in itself that a person continues to be the Advocate General irrespective of whichever government comes to power. The Chief Minister acknowledged that. this is the strength of the legal profession. Unfortunately, today, the Advocate General changes with, sorry, there's some problem here. Or is it too near? Oh, my tab is too near, okay. I can have physical papers then. Give me that. It's causing. No. My phone. My phone is not here. No, all right, my phone was good. I'm also slowly transforming myself with EPAD. Justice Chandrachud is pushing us too hard, and he is saying we have to become students. We are trying to become students. I'm learning from my colleagues who is sitting here, from other colleagues who are younger. Advocate General also taught me about how to use iPad. I've not been using it for long. Last couple of months only I'm using it. I met Mr. Lahiri, fortunate to meet Mr. Lahiri in the year 1981. Within 1 year of my starting practice in the Supreme Court. I started in 1980. I used to come Guwahati in vacations, spend time, pay my regards to the legends at that point of time, and Mr. Lahiri was the legend at that point of time. He told me two things. To advise how to become a good lawyer. Be master of facts first. Go by the first principles and then look for judgments. Analyze of your own. This is the key. There are a large number of students. Be the master of facts first. Then go to the principles of law. Read the Bare Act. Don't run to the judgments. That is the advice he has given, which I have followed. And to a great extent, I say I have succeeded because of that, to whatever I am today. Mr. Lahiri was the master of the 6th schedule. And that is what prompted my father, late Justice Ansaria, to write first edition of the book, of which I could have never thought 5th edition will come, which is being released. Honorable the Chief Justice has been kind enough to agree to release. But I could take out 5 editions because the vision which was incorporated there was Mr. Lahiri's contribution. You will find in the first edition, the first name Justice Ansaria writes, that I was encouraged to write this book by Mr. N.M. Lahiri. That is the first name in the book. And I'm really blessed to find myself that I am here today to deliver a lecture in the memory of late Sri N.M. Lahiri. I'm grateful to Justice, thank you for inviting me to deliver this lecture to this beautiful place, Shillong, the home of clouds, Meghalaya. Now the topic of today's deliberation by me is 6th schedule to the Constitution, the visionary perspective of Meghalaya. As Professor Siemli has said, to understand the present, we have to go to the past. To understand what is my vision for the 6th schedule in Meghalaya, little bit of history is necessary. Professor Siemli has taken you through 150 years from 1822 to 1972. I'll take you briefly, very, very briefly till this point of time. Now, when the Britishers came, they bracketed certain area in this part of the country. Initially, they came to Calcutta. They had East India Company. They had business interests. Subsequently, they had interest to rule us, colonize us. It's not that they were very much concerned about the development or progress of this part of the country or any part of the country. Their primary concern was to rule us. The rich natural resources called them to this part of the country, initially for business purposes. Then they wanted to administer us, colonize us. So they bracketed certain parts of this plain as well as hills as backward track. As my earlier colleagues have said, Justice Thank You had said, Professor Simli said, what made them think we are backward? I have a very, very serious grudge about using that expression backward areas, and I will say why. They presumed we are primitive. What is primitive? I love my culture, I love my place, I love my religion, I love my practices. That is not primitive. Their mindset is reflected. If you see the first document to which Professor C.M. Lee has referred, is the Regulation 10 of 1822, and it starts saying, little has been done to reclaim or civilize these people. Who authorized them to tell us how to civilize us? Then the Government of India Act 1935 came, which changed their expression from backward track to excluded areas and partially excluded areas. Here the catch is, they wanted us to exclude from the mainstream of the country. They can continue to rule us. And in fact, I find, and I believe, this part of the country was the most forward. The democracy, the rays of democracy, was in this part of the country. We had CMs, we had Lindos, we had Wahadars, but they had a darbar elected by the people. That is the democracy, that is the rays of civilization. It has gone from east to west, not from west to east. So to call this part of the country as less civilized, as backward, as excluded, this was wholly unfortunate. And as Professor C.M. Lee has given you, the entire power was concentrated in a collector. Why? Why can't we rule ourselves, govern ourselves? There slowly, in 1900s onwards, when independence movement was there, we started democratizing, certain institutions were there. But entire power in this part of the country was given to a collector who will be the judicial, executive, everything. Is all in all, as if he is the king. So everybody must stop this perception of, everybody means not everybody here, everybody hearing me, everybody in the country must stop this perception that we are excluded, we are backward. And I will show my vision at the end. I will say what is my vision for Meghalaya is. Be that as may, I'll just leaving it at the moment. Then comes the Constituent Assembly. Various subcommittees were, advisory committees were constituted. And one of the advisory committee was on fundamental rights, minorities, tribal and excluded areas. They have to use excluded areas because at that point of time, that was the expression used under the Government of India Act. That was headed by Sardar Vallabhbhai Patel. Then a subcommittee was formed for the excluded tribal areas of the Northeast under the chairmanship of Gopinath Bordole. Another primary member was Reverend J.M. Nicholas Roy, a great Khasi social thinker, political statesperson. So then the deliberation within the Constituent Assembly, within the subcommittee started. They made a report that there should be a body like district council which will have autonomy. That time of panchayats were not panchayat raj systems was much subsequent. We had the autonomy. They say it must be preserved. These bodies must be nurtured so that, as the Chief Justice said, we must be together, but we should not be forced to be together. We must maintain our identity, but then be together. So with that, in the Constituent Assembly, the report was placed. There were three sets of views, some of which reference was made by Professor C.M. Lee. One was that Assam, I'm saying Assam means broader Assam, visualized at that point of time. Many of the students may not know. Assam then included Arunachal Pradesh, not Manipur, Nagaland, Mizoram, Meghalaya, and Assam presently. They were all part of Assam at that point of time. So they said Assam was surrounded by different foreign countries. China is there, Burma is there, Nepal is there, and then Pakistan was there at that once the deliberations in the Constituent Assembly was there. So let it be under the center. There should be no provincial autonomy at all. It should be something like Union Territory. That is one shade of view. Another shade of view was, as Professor C.M. Lee has said, questions were raised. Do you want assimilation of tribal with non-tribals, or do you want to keep them separate for all times to come? Assimilation has to be by nature. You can't force people. You must love to be with each other. The third view was Bordoloi Committee report, which said district council should be there. And he said integration has to not to be by military force. It has to be by willing cooperation by all people. So that, there were certain institutions, as I said, as many Khasi states had, to run administration through Darbar, which must be maintained. So ultimately it was agreed the district council as proposed by the Bordoloi Committee would be established. And this is very peculiar. We had tribal areas in the other parts of the country. We have in Chhattisgarh, we have in Odisha. Presently we have Honorable President from the tribal belt of Odisha. For them, it is a fifth schedule which applies, which is again very rarely said. But fifth schedule is for the tribal areas, for the rest of the country other than the Northeast, and which has only one advisory council. It's just an advisory body, it has no other powers. So for the Northeast, sixth schedule was framed and was made applicable to the then United Khasi and Jaintia Hills and the Garo Hills, which presently is the Meghalaya. The entire state of Mizoram, which was then the Lusa Hills district of Assam. The Northeast Frontier Tract, which is now Arunachal Pradesh. State of Nagaland, which was then Naga tribal areas and Naga Hills district. And two districts of Assam, Mikir Hills and North Kachar, which is now Karbi Anglong and Dima Assaw. That's how the sixth schedule in 1950 was. Slowly, it has, some certain areas have gone out, and you will be surprised the entire Northeast Frontier Agency that Arunachal was a part of the tribal area under the sixth schedule, but it never applied there, in fact. It became an optional, but it was never applied. Then in Tripura, it was not there. It has been made applicable subsequently for a Tripura tribal area district. Entire whole of Tripura has one district council. In Mizoram, after it attained statehood, only in the southern part of the state, there are 3 small district councils. And district council, as my predecessors have said, is a mini constitution. It has judicial, it has executive, and it has legislative power as well. They can make laws on allotment, use, and occupation of land. It can make laws on management of forests other than reserve forest. It can make laws on use of canal for agriculture, regulation of jhum cultivation, village administration, inheritance of property, marriage, divorce, social customs, etc. It has power to assess and collect land revenue wherever it is a government land, because it is a very peculiar. Supreme Court has recognized recently in a judgment that in Meghalaya, land belongs to the people and the clan, not the state. This concept is not known in the rest of the country. This is again another thing. Ultimately, we, the sovereign, own the land, not the state. That's what is to be learned from Meghalaya. And Supreme Court has recognized that in that judgment. It was very difficult for the Advocate General was also there to convince the Supreme Court there is such a concept exists in this part of the country. That's why the knowledge has to flow from here to the west to the north. It's not state, something, some body which will give us the land. It's my land. I give it to the state for their use. That concept has been accepted by the Supreme Court after a great persuasion, because nobody buys. I remember I did a case for this Bada Bazar area, which is still a controversial thing. Whether it's a tribal area, not a tribal area, whether people, etc. I argued for almost half an hour. After that, judge says, Mr. Ansari, sorry, I have not understood anything, and we'll admit it, some other colleague will hear it. It's not to be heard. So it's little complicated. The concepts are not known to the people outside 6th schedule area. What is 6th schedule? Oh, we have heard 9th schedule, we have heard 7th schedule. That's all the knowledge is. Nothing beyond. So you have to learn from us. There are 2 or 3 issues specific to Meghalaya. Some of you may agree, some of you may not agree. One is regarding the governor's concept. Now, so we have today 6th schedule in 4 states. Meghalaya, the whole of the state of Meghalaya except the 4 wards in Shillong, which is called normal Shillong, as if the rest is not a normal Shillong, it is abnormal Shillong. Shillong is Shillong. I love every part of Shillong. My colleague has come, she went for 5:30 outside to roam around, spent 2 hours and run around. When people call it normal, abnormal, we find it very difficult, as if, anyway, some VIPs are here, at least somebody, Honorable the Chief Justice's own mind. There are certain called VIPs, very important person, as if rest of the people are not important person. All are important person in this country. That concept has to change. That's why the Meghalaya has to take a lead role. When I'm talking of Meghalaya taking a lead role, the literacy rate, for example, in highest so far as females are concerned in the country. For male is concerned, we are below average. But female literacy rate is about 84% in Meghalaya, in contrast with 66% all India average. That is what it should be learned from Assam, from Meghalaya. I'm born and brought up in Assam, so Assam comes naturally, and Meghalaya Shillong was a part of Assam when I was born. So when I come to call Shillong, it's part of Assam, it's part of my home. So when I was coming to 3 different aspects, so Meghalaya is concerned, one is the role of the governor of Assam. All laws made by the district councils has to go to the governor, and unless assented, it does not have the force of law. That's the position everywhere. All the 4 states where the district council are constituted, 6th schedule is applicable. But what is different in Meghalaya is the assent of the governor is on the basis of aid and advice of the Council of Ministers. So substantially, it is the state government which has to approve the laws. I know that entire state of Meghalaya is under district council. There are 85 to 90% tribal population, but we are diverse here also. We have Khasis, we have Garos, we have Jayantiyas. Within that, we have separate tribes. The whole purpose of district council is that they know the local conditions much better. So why should the Meghalaya district councils be an exception that the laws passed by them must go to the governor and governor exercises his powers on the basis of aid and advice of the Council of Ministers? Need to be thought of, and thorough research needs to be done. Why it should be there? Assam governor, Mizoram governor, Tripura governor does in his personal discretion. Another is the district council can make laws on various subjects mentioned in paragraph 3 of the 6th schedule, just like I said, land, custom, heritage, inheritance, village administration. If the laws are made by the district council, in 3 other states, those laws prevail. But if on the same subject, state government make laws in the state of Meghalaya, the state law prevails. Here again, there is a dichotomy. So here again, the district councils are on a second pedestal than the state, whereas in other 3 states, it is on the higher pedestal. I am aware that in other states, the tribal population in comparison to the other states' population is less, but in Mizoram also we have 80 to 90% tribal population, but there are smaller district councils, not the area. But this is need to be further researched, thought of. And we must also know that whenever any district council or the state government, parliament make laws, it has to meet the fundamental right of the people. It has to be guaranteed in Part 3 of the Constitution. No one can make laws which are unequal or discriminatory only on the basis of caste, race, sex, religion, or birth of place. It must have, every citizen has a right to move any part of the country. Freedom of speech, practices any profession. These are certain fundamental rights which cannot be violated by the district council laws, by the state laws, by the parliamentary laws even. Supreme Court has struck down some parliamentary laws which violated the fundamental rights. Under Article 14 Equality Clause or Article 19, certain freedoms are granted. And here I have said you about the powers. Now the duties are much important of the governing bodies, be it the state government, be it the district councils. As I said, we have almost the highest literacy rate in so far as the females are concerned. The male literacy rate is lower than the national average. My vision is we should have 100% literacy rate. Let's compete with Kerala. Now Kerala and Goa have on the National Human Development Index number 1 and 2. Unfortunately, Meghalaya is number 17. Let's take resolve that we will achieve 100% literacy rate. We have the cleanest village in Asia, Maulidnaum. I have gone there 2 years back. It's a lovely place to visit there. You have to see to believe it. You can't find that clean place anywhere, maybe anywhere in the world. Small village, they have kept themselves clean. The air is clean, the place is clean, people know how to keep it clean. And especially when I come from Delhi, clean air is a big asset for me. Today morning I was saying, is it not possible that we box the air of Shillong, compress it, I carry it Shillong, Guwahati, Delhi, and give it as a gift to my family, my surroundings there. That is, nature has given us so much here. Why can't we make Meghalaya a very, very important tourism destination for the country? See, again, as I said, the most on Human Development Index, which is assessed on 3 parameters, education, health, and standard of living. Kerala and Goa compete each other on an yearly basis, number 1, number 2, number 1, number 2. And both has huge tourist attraction, That is one of the reasons for the development, I think, apart from the governing bodies, governments are doing, taking steps. It's not that this here government is not doing, but tourism is to be focused. It is to be developed. You please prepare a module. Invite people. It will grow. We will grow. Though we have to maintain our traditions and customs, we have to keep our identity. We have to practice constitutional ethos, as the Chief Justice has said. Let the 6th schedule not be used only for the customary right protection. Let it be also for the development of the people. That's where the key is. That's what the youths are looking forward. I have talked to before coming here to certain persons. I have good number of friends here, to youngsters, to college students, to persons in politics. They say, yeah, what we're looking for is a good life, a healthy living, and access to education by all. Those who are in public life say, I find small children not being educated. Why? We must strive and think, yes, we will provide an 100% literacy rate. We will uplift the development index of this state, And there the district councils will play a big role under the 6th schedule because they are connected to the people. They are the local people, they are the CMs, Rajas. People listen to them because they work for the people. So that is one aspect where I will urge everyone here and listening me to take it upon themselves. That we will achieve, we will upgrade the state from at least 17 out of 25 states in the next 5 years to single digit figure at least. It's not impossible. It's only a resolution which we'll have to resolve within ourselves. People of Kerala are no exception. People of Goa are no exceptions. And as I said, we are not backward. And in fact, when I was in Assam, in Guwahati, I was born in Roha, place called Nagaon district. We look forward Shillong as coming to its people are so well dressed, people are so literate, love to come here at that 50 years, 60 years back, that continues. But others have somehow marched forward, we have lagged behind. We must increase our speed of anything. Without speed, you can run at 10 kilometers, no problem, so long as others are running at 8 kilometers an hour. But others are running at 15 kilometers, you have to increase your to 16 kilometers. That's where you have to think. We have, I was in Guwahati, we have to start using these facilities which is there. Next thing is about the administration of justice. I am from law. Now, I am thankful to the PIL filed by Mr. Chakrabarti, which has led to this separation of executive from judiciary. He filed the PIL, I think 20 years back. In Meghalaya High Court, there was a judgment by Justice Anand Patnaik that yes, state must separate the judiciary within a time frame. State government took it to Supreme Court. I represented the High Court of Guwahati then. And then apart from Meghalaya, it was extended to all the Northeast. Supreme Court pushed it, directed this High Chief Justice and Chief Minister's meeting. And fortunately, we have complete separation of executive and judiciary in Meghalaya under the leadership of Justice Banerjee. And why should people of Meghalaya not get justice from independent judiciary? When we have bureaucrats, assistant to deputy commissioner, they're executive people. Our main fight in the courts are to a great extent with the executives. So you have to have an independent mechanism. That's all we have been talking and that we have achieved. But we have some inhibition about the CPC and CRPC being applicable. On the premise we are simple people, as if the rest of the part of the country are very smart people. They're not that smart. We are much more smart. I've seen, you go to Haryana, well, the language that you speak, you can't call them smart. So this is a misconception again. This is not a technical thing. I'll give you a few illustrations. And as I said, we are simple, yes. We are not too, very complex in that sense. We say what we feel. I'm saying what I'm feeling. Some of you at the end of the day may not agree, some of you may disagree, some of you may strongly disagree, but I must speak at my home. That is what I'm doing. And as I said, it's not that people of this country, people of this state have not given good leaders, good administrators. We have Mr. P.S. Sangma, he was still respected as one of the most respected speakers of the Lok Sabha. We had Mr. Lindo, who was still treated, remembered as an independent chief election commissioner. We have Professor C.M. Lee, great administrator, former UPSC chairman. So it's not that simple, and then this is again a concept which are created. They are simple, others are complex. We are backward, they are forward. No. I'll give you a few examples of CRPC. For example, Section 50, capital A, and this is for the faculty members, for the state administrators, for the Judicial Academy especially to take into account and consider. Section 50, capital A, because where CRPC is not applicable to the tribal areas, as it is by its own force, except now with the regular courts coming into existence and then notification coming. But so far district council courts are concerned, They are bound by the spirit. District council court settle the disputes, even if a murder case is between the two tribals, is decided by the district council courts constituted by the 6th schedule. Certain provisions of CRPC, for example, section 50A, requires that information of arrest of any person should be given to the immediate relative or known person of the person who is arrested. It's very important so that person knows where it's a mandatory duty on the police to inform. If you don't inform, they can be hauled upon. Section 164 contains certain procedural safeguards for confession. We have plea bargaining provisions. We have provision under section 309 that remand cannot be more than 15 days. We have provision for anticipatory bail. Now, these are not applicable to the district council courts, and Supreme Court way back in 1970, arising from, of course, Mizoram, said a remand beyond 15 days, not bad because CRPC doesn't apply, but that affects my fundamental right. If it's a 15 days remand maximum, then the police has to produce and make out a case why remand should be granted. That provision should be applied. The Supreme Court in 2014, Benedict Maracke said anticipatory bail does not apply. So, even if you apprehend arrest by the police on a false case, you have no remedy till you are arrested. In rest of the country, you have the remedy to seek an anticipatory bail. The High Court, Meghalaya High Court said that CRPC does not apply. District Council Court judges are not session judges, so they don't have the power to grant anticipatory bail. This is wrong. We appealed on behalf of the District Council. The judgment is stayed, so the power is available today. Matter is pending in the Supreme Court. Present one judgment where a person was convicted for triple murder and given 14 years of imprisonment, though he was mentally unsound. Chief Justice Banerjee found it's something very weird. How can a mentally disabled person confession, which is not as per 164, be the basis of conviction? The Chief Justice set aside that conviction, said that you must gear up, there must be legal literacy in the legal aid lawyers, district council judges. They are the role of, again, judicial academy comes, director is here, honorable judges are here. Okay. So we can pick up certain important substantive rights which CPC or CRPC is given, which may be made applicable to the district council courts as well. As if district council courts are not for anyone else except among us. Of course, customary cases they can decide, but then CRPC has certain rights which are given to the accused persons, valuable rights which protects your fundamental rights of a fair trial. So we can at least pick up 10, 20 rights under the CRPC, which should be made applicable to the district council courts. I have given you a few examples. Study can be made by the faculty members, by the students of the law colleges. Some research paper can be done in cooperation with the Judicial Academy, and something can be evolved taking into confidence with the district councils, because they make the district council rules applicable to the district council courts. And last is regarding inner line permit. I am aware that there is a strong inner line permit is what? It is framed under an East Bengal Frontier Regulation 1873, which was framed for governance, good governance and peace. Now, what is inner line permit? It requires persons to come from other parts of the country to its own country, and you require to have some sort of a permit from the government. You have to seriously think about it. It is applicable to 3 states: state of Mizoram, state of Nagaland, state of Arunachal Pradesh. Now Manipur has also been made applicable. I am aware that a demand is there. There is perhaps a resolution of the Legislative Assembly. There is a law which has been made, Meghalaya Resident Safety and Security Amendment Act 2020, which is something at par that anybody coming to Meghalaya for for 48 hours or more is to give information about in a prescribed format. If he does not do so, he can be prosecuted. That bill is pending before the governor and the president. But why is it required? Now please feel, I really felt bad once I was going to Arunachal for a family visit and I have to apply and I have to get it, check, get people ask me, kahan ja raha hai, kyun ja raha hai, kitna din rahega, kahan rahega. Now think you're going to reciprocal, suppose reciprocal laws are made in some other parts of other states. You go to Delhi, you go to Bombay, state of Maharashtra said, if you have an airline permit, we require an airline permit for you. Have in Karnataka, we require an airline permit, we require an airline permit from the residents of that. You feel really awkward. Please feel free to talk about it. It's not that, see, Britishers have bracketed us as backward track, excluded areas. Please don't look over perception. Have a free discussion, free debate of this. Ultimately, we need a development. We need a developed state. We need a human index development to grow. Yes, we have to protect. We have to unify it. But it's not homogenization, as the Chief Justice said. Because India is the best example of unity among diversity. And when we come to Northeast, it's a rainbow. It's a rainbow of 7 colors. The 7 states are extraordinarily diverse, mysterious, colorful. But we are a one bunch of cloud. We are diverse yet together. We go with the winds together. We are home of clouds, we are Meghalaya. Please think in that line. We are one. So, please feel free. See, there are certain economic, certain political compulsions. People get swayed away in different parts of the country when we talk of on certain basis. Let's not talk on place of birth or religion or something, because today there is a race, unfortunately I feel bad, there is a race who is more backward. Other backward, most other backward, more other backward. Let's have a race in Meghalaya. I am the most forward state in the country. I have the highest human development index in the country. My vision for Meghalaya, for the 6th schedule area in Meghalaya is, we the people of Meghalaya resolve, as we have resolved in the Constitution, we the people of India, we the people of Meghalaya resolve to achieve 100% literacy rate, 0% infant mortality rate, and we also resolve to make state of Meghalaya as the most forward state on the Human Development Index. That is my resolve. In next 5 years, we can do it. If all of us, so many of us have come here on a Saturday morning to hear us. If we resolve, we can do it. Nothing is impossible. With that resolution in mind, with that vision in mind, we nourish our culture, we nourish our heritage. This is heritage. Let us give rays of civilization, which they say that we are not civilized, 1882 regulation says, to the other parts of the country. Let's travel to the other parts of the country. Let the people from other parts of the country travel here. Ultimately, the money of the taxpayers are utilized for the entire country in different parts of the country. So with this, I'm extremely, extremely thankful, and I really feel at home whenever I come to the Northeast and be part of you. I've met so many friends here. All the members of the bar are good friends of mine, sitting here, sitting there. I exchange pleasantries whenever today, unfortunately, is not a working day. I come to Shillong, I definitely go for a cup of tea. I ask them that please invite me and we'll have a cup of tea together. Spend good time with them. And at the end, I'm extremely thankful to you. I'm also thankful particularly to the Honorable Chief Justice Sanjeev Banerjee, who has agreed to release the 5th edition of Justice Ansaria's book on 6th schedule. And as I said, I have some other books on juvenile justice, we have 3rd edition. I have writ jurisdiction on 2nd edition. I have Chronicles of Indian Constitution, which is 1st edition. But This 6th schedule book is only for when I went to the publisher for the first time, I asked him that it is only for the limited year, would you publish it? And they came back to me after 3 days, you will publish it. Now every 5th year, I get a request from that, please publish it. So this shows the love and affection of the people to learn this part of the area. And also failing my duty, my publisher, Mr. Vinay Aja, was supposed to be here of Mohanlo House, who could not come because of the health issues. And he published it within a shortest possible time. I gave him manuscript about 15, 20 days back. Within 20 days he could publish. I say, I want to go to my place and then release it there. And he did it, a magnificent work, which would be available just now. And I also thank my colleague Kavya, but for whom I could not have done it, they revised the book within this shortest possible time. And finally, I greatly thank Justice, thank you, not only for giving me this opportunity to speak with you, but admire him for his Guru Dakshina he is paying today to his Guru, Sri Lahiri. And it is said that the parents give birth to a child, to a human being, but teacher makes us fit for serve the society. There is a doha in Hindi by Kabir. Guru Gobind dono khade, kaku lage paye. Balihari Guru aapne, Gobind diyo bachaye. They translate it into English is, there is a Guru and the God. Whom do I worship first? And Kabir says, Guru first, because he told me he is the God. That's what you have done. Justice, thank you. It's really give me immense satisfaction that a junior, as Chief Justice said, the relationship of junior and senior has to develop. You have to respect your senior, and the junior has to make himself or herself indispensable, so that whenever you see, oh, my junior is not there, I'm handicapped. Be that, I went to so many law students are here. Your perception must be in the first few years. Again, the Chief Justice said now today the craze is for who is getting a highest pay package on coming out of the college. Let that not be the perception, at least for 2 years or 3 years. You should be eager to learn. And this learning, I have also learned my pay package, I don't want to say because many of you will laugh you. But first 2 years or 3 years which I learned, I am achieving that even today. I am reaping the harvest which was done at that point of time. I used to start at 7 o'clock in the morning, take a bus, which was the costliest vehicle at that point of time, but keep standing and avoid paying to because I didn't have that much of money, to the ticket checker, till 10 p.m. in the night. But 2-3 years makes a complete difference. With these words, thank you very much. Kublai. Thank you.
Thank you, Mr. Hansaria. Now we are happy to know that Mr. Vijay Hansaria has now come out with the 5th edition of Justice B.L. Hansaria's 6th schedule to the Constitution. I would like to request the Honorable Chief Justice to kindly come on the dais, and I would also like to request Honorable Justice, thank you, Justice W. Dingdo, Professor Imli, Mr. Amit Kumar, and then a family member of late N.M. Lahiri, Mr. Surajit Datta, and Mr. S. Chakrabarti to kindly join us here. Thank you. We have now come to the end of this program. I would request Mr. Banlumlang War Pira to kindly give the vote of thanks.
On behalf of the organizers, we are very grateful to our two esteemed speakers, Mr. Hansaria and Professor Semle, for their very enlightening and knowledgeable, informative lectures on the 6th schedule to the Constitution of India, Visionary Perspective of Meghalaya, and the overview of the administrative structure, policy and pattern of the hills in Northeast India, 1822 to 1972. These subjects are especially relevant for us on this 50th year of Meghalaya, of the statehood of Meghalaya, and on the 100th birth anniversary of our late senior, Mr. N.M. Lahiri, who was the Advocate General of Meghalaya for a long and continuous period of 31 years, from 72 to 2003. Lectures are also a befitting tribute to Mr. Lahiri, who was a leading light and an authority on the 6th schedule of the Constitution of India. He can also be looked upon as one of the pathbreakers for the formation of the state of Meghalaya, and we are also thankful to our speakers for having kindly consented to spare their valuable time and to take efforts to prepare and share their thoughts on experiences on the subject as a tribute to Mr. Lahiri and in memory of his life. These were well-researched lectures, which we understand from the way that they have discussed and delved into the subject, and we are truly grateful, and we feel that the students and everyone here will greatly benefit from these lectures. And our sincere request is that, especially for the students, to go back and to research more on these matters and try to keep track of the developments. In this connection, at the conclusion of this thought-provoking session, the organizers wish to thank the Honorable Chief Justice, the Honorable Judges of Meghalaya High Court, for making the session a possibility. We wish to thank also the officers and protocol staff of the High Court who have volunteered their services and have helped in arranging for this event. We thank the Honorable Chief Minister and Honorable Health Minister for their encouraging messages. We also thank the Law Secretary, Secretary Law and the Law Department for their efforts and for their help. We are also thankful to the Law Department for their kind gesture in hosting the lunch in honor of the former Advocate General, late Mr. Lahiri. We thank the Director of Meghalaya Judicial Academy, who had taken a lot of efforts and coordinated the event. We thank the Advocate General and the staff of the Advocate General's office for their coordination and efforts for this event. We also thank the President and members of the High Court of Meghalaya Bar Association and members of the Shillong Bar Association. We also thank the members of the District Administration, the police for all the assistance in the organization of this session. We also thank the authorities and staff of this convention center for the efficient arrangements and for making the session a possibility. We thank the members of the press, electronic media for their coverage of this event. Last but not the least, we thank the members of the audience and all those who are present here, especially the law students, and we trust that it will be enriched by these thoughts. I apologize on my own behalf if we have left out anyone in this mention, and we would like to inform and for you to know that we acknowledge all the efforts that you have made. Last also but not least, the efforts which Justice Thankyo has taken in organizing this. I think it's the first lecture, so we are thankful to him for taking this effort in memory of our late senior, Mr. Lahiri, and we wish that this should be an annual event. So let us hope we carry forward in the years to come. Thank you. Thank you, sir.
Thank you. So I would request all of you to join us for lunch. which is arranged on the two halls along the corridors. Thank you.